It's an honor to welcome Bruce Pardy on the show. He is a senior fellow at the Aristotle Foundation, as well as the professor of law at Queen's University. He recently published a column, technically two columns, for the Aristotle Foundation. One is titled A Right to Unequal Treatment. In Canada, some people are more equal than others. And a related column relating to the Toronto Metropolitan University Medical School is titled at TMU Medical School, Some Students Are More Equal Than Others. So, for the most part, we are discussing the difference between equality and equity and the difference between the US Constitution and the Canadian Charter of Rights and Freedoms. So, Bruce, welcome to the show. How are you?
Thank you very much for having me. It's a pleasure to be here.
Okay, so was it your idea? Or was it the people at Aristotle Foundation that came up with the Orwellian heading?
Oh, I'm afraid that was me. Yeah, that's of course an allusion to Animal Farm, the penultimate line in the book of George Orwell's great allegory of communism. Really, I mean, there's some people who wonder about whether or not he was speaking about Soviet Russia in particular or the idea in general, but as people will know, it's a terrific story.
Mhm. Okay, so let's talk about the difference between equality and equity. And I'm sure, like me, these two terms being put close to one another will remind you of that one particular meme that was widely shared on the internet about those kids standing outside the baseball field diamond.
Right,
Uh,
right.
I think equality means they both standing on the same crate or box. So I think two of them cannot see, but then equity means that the shorter one stands on two or more boxes, while the taller one does not have to stand on any boxes at all, and all that. So, what do you make of that allegory, that picture, by the way?
Yeah, I think that allegory works better if you imagine those three kids instead of as spectators trying to watch over the fence. Imagine them playing on the field in the game. One of them is fast, one of them is medium, and one of them is slow. Let's say they're playing soccer. So equality in that scenario means that the rules of soccer apply to all three of them equally. And the rules of equity would mean that the referee is suddenly going to apply a different set of rules to the slow one than to the fast one. That doesn't make any sense. If you apply, and so let's start with this, everybody is different. In other words, everybody is unequal in characteristics, in skills, in background, in education, in wealth, and inclination, and so on. And so we have two choices. Either the law can be applied equally to all of them, in which case they will probably end up in very different places. Or we can say we have to have the law make them end up in the same place, all of them. And that would mean that we would have to apply different rules to each one of them. So, in other words, you can't have it both ways. Either the law is going to be equally applied equally to everybody, or we are going to make a different set of rules for everyone so that you create equality in the result, in the outcome. And when those three kids are playing soccer on the pitch, the one who is the fastest may may well score more goals. Um, but so what? I mean, that's the nature of the competition. And if we're going to allow competition in the society, then the same rules have to apply to everybody.
Okay. So, I'm reminded of the short story Harrison Bergeron by
Oh, yes, great story.
yeah.
Yes.
For those who are not familiar, it follows a sort of dystopian world wherein people who are excellent in any way, shape, or form are hampered by, well, one by the state and two by certain mechanical devices, say wearing lead shoes if you're a fast runner, or wearing a helmet that beams like high frequency sounds in order to
Right.
hamper your thinking if you happen to be a, a whiz kid. So I wonder, in the case of the Toronto Metropolitan University Medical School, formerly known as Ryerson
Right.
University Medical School, is something akin to Harrison Bergeron happening here?
Yes. Yes, in a way. It's not exactly the same, but it is in a way rather than by, well, it's burdening a certain group of people by providing other groups of people with better access to a resource. So a seat in a medical school is a scarce resource. And you can distribute that resource by a different set of standards. So what the question is, what set of standards are you going to distribute it by? Now you could just sell them to the highest bidder, but that means you would end up in medical school with people who could pay for it, but perhaps weren't academically um, set for it. You could, as most educational institutions claim to, you could base it upon academic merit and admit the highest achieving set of applicants that you receive. But in this case, Ryerson, TMU, has decided to um, allocate seats on the basis of identity. A quarter of the seats for Black applicants, a quarter of the seats for Indigenous applicants, and a quarter of the seats for members of other groups like LGBTQ, and so on. So what you have there is you have a disenfranchising of anybody who does not fit in one of those groups. In other words, the seats in medical school will be scarcer for people who do not fit into one of those groups. And therefore, it's not exactly like putting lead boots and earphones on people like in the story, but it is essentially achieving the same thing by disentitling them to compete for the space.
Mhm. Okay. And I suppose that brings us to the our neighboring country of the South America,
Yes,
and with their student for fair admissions versus Harvard last
right,
year, which was successful. And it was a decision that I welcome, not just because I happen to be Asian and people like me would have a better shot at being accepted into Harvard University and such,
right.
but it also represents a big step for, well, fairness. Well,
Yeah,
fair.
right.
Okay.
Yeah.
Um, so tell me, why and how did the Americans manage to figure out this question of, well, elevating one group at the expense of another is not fair, whereas the Canadians so far haven't?
Yeah, that's a very good question. So we should acknowledge first that this kind of thing has been going on in the U.S. as well.
Yeah.
There's a lot of um, instances of this equity approach being installed in American institutions and so on. The difference, as you alluded to, is that the U.S. Supreme Court has now last year confirmed that the constitutional requirement in the U.S. is equal protection, not equity. And so they may be able to sort themselves out in time. In Canada, our Supreme Court has been saying for decades, like 35 years, ever since they started to interpret the relevant section under the charter, that the charter, even though it's worded as though it should create the same right as in the US. If you just read 15.1 of the charter, you would think, oh, this means the same thing as equal protection in the US Constitution. But our Supreme Court has said, no, it requires substantive equality, and substantive equality is another word for equity. And why that is, well, there's a different culture in the two countries. Um, and there's a bunch of historical reasons probably as well. We had a federal commission on equality in employment just shortly before the first Supreme Court decision on this section. I don't know what effect that might have had directly, but the the rule of law, the status of the rule of law, and the of liberty provided by the Constitution, and those related ideas that the Americans hold dear to their hearts don't have the same history in Canada, and therefore don't have the same cultural strength here. And we've ended up, as you alluded to, in a very different place, and it's going to be very much more difficult for us to get out of the hole now that we have dug.
Yes, I should mention also that the 14th Amendment was not in the original Constitution, so to speak, and it wasn't the original Bill of Rights, even. It was added into the Constitution along with Amendment 13th and 15th, following a brutal civil war that
Right, right,
tore the
right.
nation apart due to a very important question of should we tolerate slavery in our borders, and such. So I assume Canada, that, although it has this cultural conflicts between the Anglos and the Francos, it does not have nearly the same kind of tension that would lead to a war as such. So maybe that
Well,
can.
I mean, it was not that there was no conflict, but there wasn't a conflict like the American Civil War in Canada's history, and Canada really didn't have slavery.
Mhm.
Uh, from the moment of Canada sort of being a self-governing country, slavery is not part of its history, and in fact, for periods, Canada was one of the places that slaves would flee in order to escape. So we didn't have the historical circumstances, perhaps, to act in the way the Americans did. But there's irony there, right? Because the Americans have ended up with a much stronger guarantee of equal protection than we have here.
Yes, but I suppose the indigenous population, or at least in the realm of Canadian politics, have taken the place of the Black population in the US, as in the people with a long-standing history of oppression and discrimination, and now with a legitimate claim, um, of grievances and such. And
Mm-hmm.
as um, affirmative action programs, especially those that are applied in Canadian college campuses, now favor indigenous populations. And
Yeah.
many cultural programs too. I remember I was studying at Trent, and that's when I first learned of the land acknowledgement
Oh
that
yes, yes.
started almost every lecture. And also, I was uh, I was early enough for this, but people who applied to, or sorry, who were freshmen after me, they had to pursue at least one uh, accredited Indigenous Studies course uh,
Right,
for
right,
them to pass or to receive the Trent degree, whichever program that they happen to be in at that time.
right.
So, for in terms of these claims, historical and present day discrimination, how much are legitimate and should be paid attention to, and how much are just results of, well, previous politics?
Well, I would put it this way: there were times in history where indigenous peoples, as well as other kinds of people, did not have the same legal rights as certain other people. You could talk about indigenous people, you could talk about women, you could talk about black people, and that was an application, or if you like, a breach of the principle of equal treatment under the law. I mean, you can't have some people able to vote, for example, and not other people. You can't have some people able to own property and not other people. That's a breach of the Western principle of blind justice and equal application of the law. If you look at the situation today, that doesn't exist. There are no rights that I would hold as a white man in Canada that everybody else doesn't have. So in that sense, the law does not discriminate against anyone. And those historical moments have passed. And in fact, if you'd like to put it this way, Indigenous peoples in Canada have are the legally privileged group. And what I mean by that is this: Indigenous peoples hold the same legal rights as everybody else. They're allowed to do all those things. They're allowed to own property and vote and marry and divorce and hold a job and go to school and all the things that Canadians can do. Indigenous peoples are able to do individually because they're Canadian. But depending upon the their group affiliations and lineage and history, some Aboriginal people have additional rights, legal rights that other Canadians do not have. And so, if you are to make a legal argument about how the law works and whether or not there is equal protection of the law in this country, you might make an argument that it is, in fact, and maybe this sounds ironic, but it's in fact the Indigenous peoples, or at least some of them, that are the legally privileged group. And if we go back to that sort of Western liberal idea of that that the idea that your lineage should not matter, that justice should be blind, that the outcome of a legal proceeding or your legal rights should not depend upon who you are, but that the law should treat you in the same way as everybody else. Okay, if that is the principle that we're after, then we are breaching the principle by accepting the idea that people should be treated differently depending upon whether they're Aboriginal or not, as we do with other groups as well now, but not nearly as extremely as we do with the Aboriginal.
So the way I see it, certain affirmative action programs in the case particular of the Toronto Metropolitan University,
Yes.
uh, I think two or three rationales, I think three rationales can be made for this application. Well, one is anti-discrimination, as you've mentioned in the Canadian Charter of Rights and Freedoms. There in Section 15, the first clause says that there will be no law that are explicitly discriminatory against any members of any group. But
Right.
the second clause following that says that, well, that doesn't mean that there should be programs of such a kind that Toronto uh, Metropolitan University is applying that elevate certain groups which are historically disadvantaged um, to, say, higher positions. And
Mhm.
they do that with the aim of reducing discrimination between these groups, Blacks, Indigenous, LGBTQ plus people by elevating their representation within a given field. So does that work? Like would that kind of action achieve that purpose of reducing discrimination, like group-based discrimination when it comes to these populations?
Oh, if you're asking me if these things work, my answer would be no. In fact, this kind of thing is going to act to the detriment of everyone. But first, before I get to that, though, let's just make it clear that this. So, first of all, just to be legally accurate, it is quite possible that the charter guarantee here won't apply to the TMU example because it's not clear, the courts have not made very clear whether or not universities are to be considered part of governments or not. And the charter just applies to the government. Even if it does not, though, there is essentially an equivalent rule in our human rights codes that will apply. And so either way, you're dealing with the same kind of question. So it is probable that a challenge to this program, if you were to challenge it constitutionally, it would probably pass muster. I wouldn't expect the Supreme Court of Canada to strike this down because it's consistent with what they've said on the subject. So we're not starting with the proposition that this is clearly illegal. That's not what I'm saying. But whether or not it is effective, I would say that this is to the detriment of everybody involved. Number one, it's detrimental to the people who don't fit inside those groups, as we alluded to earlier, but it's detrimental also to the people who do, because what it's going to do is it's going to diminish the reputation of the ability of doctors. Let's say you're a doctor and you went to TMU and your certificate is on the wall in your office as people come in. And if it becomes more widely known that TMU has the admission policies that it has, then if you're a patient of one of those doctors, you're going to think, oh dear, this person was the beneficiary of a DEI program wherein they didn't have to show the same kind of accomplishments and credentials. It wasn't a fair competition. It's a product of favoritism. I'm not sure if I should trust this doctor. And that is going to affect that doctor, but it's also going to affect other doctors who are in those groups and who got into medical school on their own merits and are perfectly well qualified and skillful and so on. There's going to be the potential of doubt about their skill and qualifications, and that's that's unfair. That's not fair at all. They've reached what they've done on their own from their own efforts on their own merits, and so the mere fact of doing things this way has a detrimental effect on everybody involved.
Right. So the second rationale would be to redress historical grievances. And I think this, for the longest time, has been the the primary rationale for these affirmative action programs. And I think I can kind of see that. In Ivy League American schools in the early 20th century, Jewish people were admitted according to a quota system. So, yeah, above that quota, the barrier of entry is basically shut out for them. Uh,
Sure.
so, would a would a program that say make it easier for previously excluded groups like Jewish people in American universities, or I suppose in the case of Canadian universities, Indigenous people be lowered? Would would that would the entry requirements make it easier, help them in any way, help reduces these historical injustices?
Well, there's an assumption in your question which I want to address, which is this. So once we start down the road of instituting affirmative action programs like this and proceeding on the basis of equity, we we have made this leap that individuals are not individuals; they are members first and foremost of groups. And if the group that they have allegiance to or have belonging to was at some point in the past discriminated against, therefore they have also been discriminated against, and therefore in the present we have to give them an advantage. That doesn't follow at all. That only follows if we insist upon thinking of people as members of groups. If you think about people as individuals, then the question is, has this individual been discriminated against? In other words, here's my credentials, here's my achievements. Will you please assess my competitiveness on the basis of those and not on my identity? And the answer is yes. That is, we will take your record and we will assess it in a neutral way without regard to who you are. Then you are not being discriminated against. Um, the situation with quotas and so on for Jewish students that you alluded to. The problem with that is exactly what I'm describing, which is you've got a quota for a group. That's not okay. You should be assessing every individual, regardless of whether they're Jewish or not, or whatever else they are, on the basis of their accomplishments, not their identity. And the way that you fix that is to prevent that kind of calculations of groups and instead insist that institutions treat individuals as individuals. Right? What we're doing is we are, in order for the claimed purpose of defeating discrimination, we are creating discrimination. This is the approach. So if I can contrast two things, we have anti-discrimination and non-discrimination, and those two things are opposites. Strangely, they sound like the same thing, but they're not. They're opposites. Non-discrimination means you shouldn't discriminate on the basis of identity. Period. Every individual is an individual. Treat them that way. Anti-discrimination basically says we are going to discriminate, but we're going to discriminate in the opposite direction. we're going to discriminate against the right groups and not the wrong groups. Well, that is an entirely, for my money, an entirely wrong and terrible way to go about things.
Okay. So the third rationale, and I would argue is the worst, and it also happens to be the one that is popular right now, is as you alluded to, the DEI trifecta, the D part of it. So
Right,
diversity.
right.
Um, yeah, TMU may have thought that we do not have enough indigenous Black LGBTQ plus voices in our medical school. So
Right.
if these voices and peoples are included, then we may have a more diverse uh, field of epistemology, so to speak, when it comes to medicine. Um,
Right.
uh, I guess certain indigenous ways of knowing, so to speak, can be included
Yes.
that
Right.
can provide a counterpart to, Western science. So I guess if you can detect the certain mockery in my tone, I certainly
Yes.
ah,
Right.
it's anti-diversity. So, but nevertheless, how would you, a legal professional, define diversity?
Oh, well, okay, so that's a very, very good question. So real diversity, as I would identify it, is a diversity of belief, of thought, of opinion, of approach. The diversity they're talking about is the diversity of appearance. And ironically, they're not looking for actual diversity as I would define it. They're looking for the opposite. They're looking for diversity of appearance, but conformity of approach. In other words, if you don't believe in their approach, if you don't believe in DEI, then they don't really want you no matter what color or race or gender you are. They want people who agree. And it's very interesting to watch how authorities and institutions um, treat people who otherwise might appear as though they belong to the right groups who are going to be favored until they step out of line and don't agree and object, and then they become the enemy too. So this claim of working towards diversity, for my money, is exactly the opposite. Exactly the opposite. They are trying to do things in a way that requires people to get on board with the program.
Yes, it is anti-diversity also because they would assume that if you belong to a group, you think of a certain way, whereas if
Yes,
you
yes,
think in terms of individuals, then everyone thinks in different ways, regardless of group.
exactly so. Exactly so. Yes, correct.
Yeah. So finally, since we're talking about rights and freedoms, in what ways have Canadian society in particular misread the meaning of rights, and how can a proper definition of rights be restored?
Yeah, that's a good question because more and more people, I suspect, more and more people imagine rights as what I would call entitlements, the right to receive things from the government, the right to have the government do things for you, the right to have the government keep you safe, the right to oblige government to act on your behalf. And that is not my idea of a right at all. I'm talking essentially about positive rights, as they are sometimes called. Whereas a proper, and this is from my point of view, of course, but a proper constitutional right in any event is a negative right, meaning a right to prevent the government from interfering with you. And and negative rights tend to work to preserve your liberties. And equality is one of those rights in the sense that it prevents the government from making up special rules for you or your group that don't apply to other groups. And so the case that I would make with respect to the way rights have been twisted, if you're gonna put them back together, you need to get rid of the idea of equity and go back, as we started this conversation, go back to the idea of requiring the law to treat people equally.
On that note, and I could not agree more. Thank you very much, Bruce Pardy, for joining the show.
Thank you very much for having me.